Hello, everybody, and welcome to Horty Springer's Health Law Expressions podcast. Today we have some good news for patient safety organizations. There's an 11th Circuit case that just came down in May of 2024 that has significantly altered the way in which the Patient Safety Act, at least from the standpoint of the government, has been interpreted. My name's Dan Mulholland, and with me is my partner, Charlie Chulack. And we want to talk to you about this case, but basically, we wanted to set the table by talking about patient safety organizations. You may well have one in your health system. You may have a contract with a patient safety organization, but those were things that were created by a law passed in 2005, a federal law that provided a statutory privilege for information reported to or held for reporting to patient safety organizations. Very muscular privilege. It applies to any kind of action in either federal or state court or administrative proceedings, and it's almost absolute, far more muscular than any kind of peer review protection statute at the state level. The Patient Safety Act has been in effect for all this time. Regulations were promulgated in 2008, but the government had interpreted this in some informal sub-regulatory guidance as saying that you could only get a protection for information that was created for the sole purpose of reporting to a patient safety organization, which constricted the ability to take advantage of the privilege if the information that was at issue could be used for other purposes. But now there's a great case from the 11th Circuit Court of Appeals that has done away with that sole purpose test. And Charlie, maybe you could tell us about that case.
Yeah, sure, Dan. And we were really excited when this case came out. It's called Inray Baycare Medical Group. And it was issued by the 11th Circuit, as Dan said, in May 2024. So relatively recent case. And, just to give you a little bit of background on our court system, for those of you that aren't in the legal profession out there, we have two types of courts in this country. We have state courts. Each state has its own set of courts. And then we have federal courts. And when we talk about federal courts, we have district courts, federal district courts, which are the trial courts. And then we have federal circuit courts. And then we have the United States Supreme Court. Now, circuit courts are the appellate courts in the federal court system. When a circuit court issues an opinion or makes a holding, it's very influential, especially if it's on a federal law such as the Patient Safety and Quality Improvement Act. So just wanted to give you that background, that this is an important case, and it's very, very influential when it comes to other courts that will interpret the privilege protections for patient safety work product going forward. So again, great case, important case. What it says is consistent with what we've always thought the privilege protections for patient safety work product under the Patient Safety and Quality Improvement Act and the 2008 regulations said. Dan talked a little bit about the HHS guidance from 2016 where they articulated that sole purpose test. Now, when that guidance came out, we were like puzzled because it seemed to be inconsistent with the regulations, and the regulations really announced a very broad and, like you said, muscular privilege. But Inray Baycare Medical Group, this 11th Circuit case that was issued in May 2024, seems to get back to everyone's understanding of the regulations and the privilege under the Patient Safety and Quality Improvement Act. So
HHS has basically made up that sole purpose test. There's no basis for it. I mean, I helped out with some of the regulations in 2008, and it was specifically broad, so that wouldn't be the case. And I don't know who did it, but somebody came up with that good idea. Let's just say it has to be for a sole purpose. But now, as you say, Baycare has revisited that.
Yeah, and I mean, when we were thinking about it, I actually wrote an article for an industry journal on the case, the Tibbs versus Bunnell case from the Kentucky Supreme Court, which came before HHS's guidance and also talked about this sole purpose test. And if you think about it, if patient safety work product, the privileged information under the Patient Safety and Quality Improvement Act, if it can only qualify as patient safety work product, if its sole purpose was for reporting to a patient safety organization, what does that leave?
Yeah.
I mean, because all information Hospital industry, the healthcare industry in this country is so regulated that most information is touched by some requirement or mandate or obligation under federal or state law. So HHS, through its guidance, pretty much eliminated all information. That's why we strongly disagreed with it.
Oh, yeah. I mean, nobody just keeps information for the sole purpose of reporting to a patient safety organization. The purpose of the law was to protect the kind of things that you might be doing that a patient safety organization could help you with in terms of analyzing the data, compiling the data, and reporting it back. And I was clearly against both the statute and the regulations, but that's neither here nor there now that we have the Baycare decision.
Yeah. So let's talk a little bit about the Baycare decision. We could talk all day about PSOs and patient safety work product and the privilege that applies to patient safety work product. But this involved a surgeon, and she was terminated by her employer, Baycare Medical Group. And she was terminated for committing surgical errors. So she sued, and as a part of her suit, she claimed that she was discriminated against in this employment action. And she sought discovery from Baycare. And some of the information that she was seeking, as you'd expect in an employment discrimination suit, was information, peer review information about other surgeons. Because her claim was, well, I was being treated differently. There were other surgeons that committed surgical errors, but you didn't terminate their employment. That was the gist of her case or her argument. And Baycare turns around and says, well, this information that you're seeking about these other surgeons, about these other physicians, is a part of our patient safety evaluation system. We're compiling this information as a part of our patient safety information or patient safety evaluation system. Therefore, it's patient safety work product. And as Dan said, under the Patient Safety and Quality Improvement Act, patient safety work product is privileged and confidential. You really can't get at it if it qualifies as patient safety work product. Well, the district court, the lower court, the trial court says, well, this can't be patient safety work product because you weren't developing it for the sole purpose of reporting it to a patient safety organization. And the district court goes on to acknowledge several information maintenance requirements in Florida law, because we're in the state of Florida here, even though we're dealing with the 11th Circuit, which includes the state of Florida. They say, under Florida law, you have to maintain certain committee minutes and peer review records, and you also have to report certain information to the state. This information that you're claiming as patient safety work product touches on that maintenance requirement and that reporting requirement. So you can't have developed it for the sole purpose of reporting to a PSO. So bottom line is district court says it's not protected. Baycare appeals that to the 11th Circuit. And they say, listen, sole purpose test has no grounding in the Patient Safety and Quality Improvement Act. And the 11th Circuit agrees with Baycare. They say, yeah, we don't see evidence of this sole purpose test anywhere in the language of the statute. That is the Patient Safety and Quality Improvement Act. And another thing that the district court had said is that Baycare was using this information for internal quality analysis. So they were using it for other purposes internally. So again, it can't be the sole purpose that it was created couldn't be for reporting to the PSO. The 11th Circuit takes issue with that as well. And they say, listen, in the preamble, HHS actually says that patient safety work product or information that's in your patient safety evaluation system can be used pretty much for any reason internally. So they say that contradicts the district court's finding, contradicts statements made in the preamble to the final regulations for the Patient Safety and Quality Improvement Act. But the bottom line, and I know I'm being long-winded about this case, probably because I'm pretty excited about it, as you can tell.
Charlie, you got to get a life. It's okay.
Yeah. But the bottom line is the 11th Circuit says, well, there's also this prong of the definition of patient safety work product. That is, patient safety work product includes the deliberations and analysis of a provider's patient safety evaluation system. And this information checks that box of the definition. So I think that this is the first circuit court case that actually recognizes that information can qualify under the deliberations and analysis prong of the definition of patient safety work product, which is also very, very important. And the last thing that I wanted to mention is that the 11th Circuit dismisses the plaintiffs, the surgeon's argument that, well, listen, we have these reporting requirements in Florida. They can't use this information, for reporting to a PSO and also to satisfy those reporting obligations. If you're in the state of Florida, there's Code 15 reporting requirements, and that's what they were alleging. You have this reporting requirement. It can't be patient safety work product. The 11th Circuit says, well, Baycare presented evidence showing that they satisfied those reporting requirements with separate information, not with this information that you're seeking in the litigation. So very important case. Primarily, the 11th Circuit does away with the sole purpose test. They say we don't see any evidence of the sole purpose test in the Patient Safety and Quality Improvement Act's language. And they also talk about patient safety work product qualifying as such under the deliberations and analysis section of the definition.
Yeah, no, that's a good summary, Charlie, and it is legitimate to be excited about this case. If you're looking to protect peer review information, quality assurance information, especially in the context of this case, the hospital had a couple strikes against it. Number one, it was in Florida. Florida had pretty much gutted its peer review protection years ago by the so-called Amendment 7 to the Constitution that said that patients had a right, constitutional right, to get information about their care, which would include peer review information. Second, it was a federal discrimination case, and there was a case, Vermonti, a few years back, that said that in those kind of cases where a doctor is alleging discrimination on the basis of race, gender, national origin, they can get access to other doctors' peer review records because it's a federal action and the state peer review law doesn't apply. So big win there for Baycare. But beyond that, I think this is going to make a lot of hospitals and health systems rethink their strategy with respect to PSOs. For instance, if they have a contract with a PSO now, you may want to revisit it to see if peer review and quality assurance information can be fitted within the definition of the patient safety work product and patient safety evaluation system that that contracted PSO uses. And Charlie, I know you've set up a number of PSOs that were directly operated by health systems and hospitals. Some of our clients are looking at that now too, and it might be something that's worthwhile.
Yeah, I mean, I'm going to say a lot of interest in health systems, creating their own patient safety organizations or contracting with an already existing patient safety organization. I mean, I think it's exciting times for health systems because, as our healthcare delivery system has, become more systematized in the last 10 to 15 years. And what health systems are looking for is to have this central area or central entity where all the providers in their system can report information, and then that central entity, which would be the patient safety organization, can crunch the data and then report back to the providers in the health system with things like, recommendations for clinical protocols, comparisons, when it comes to how you're doing compared to another hospital or another ASC that's in the system. So, a lot of opportunities here. And I think that this 11th Circuit case is going to, spur the interest in PSOs even more.
Oh, absolutely. Especially a multi-hospital system or a system with operations in several states. This gives you protection that you couldn't get individually because you have different state laws that apply to different types of organizations. So I think it's a big win. It's something to look at, and hopefully this has been helpful to you. So join us again for another Health Law Expressions podcast in the future. But for now, I think we probably talked all that you want to hear about patient safety organizations. If you ever need to get in touch with us, you can always do so.
Thank you.